Hi, I'm Rob McKenna, Washington State Attorney General. Thanks for joining me for a few minutes to talk about the lawsuit that Washington State has joined in Florida regarding certain provisions of the new health care law. The way my involvement in this case came about is that I was contacted about a specific provision in the health care law called the Nebraska Compromise. It's a provision that's supposed to be taken out of the law that indicates that Nebraska will be the only state in the country to receive 100% federal match forever for its increased Medicaid costs. I joined with another state in drafting a letter to the Speaker of the House and the Senate Majority Leader in Congress. Many other states joined us in that effort, and we're told that provision has been taken out or will be soon. While I was working with other state AGs on the letter to Congress regarding the Nebraska provision, we began talking about other specific provisions in the law that concern us. There are two provisions that we're really focused on in this lawsuit. None of the other hundreds and thousands of provisions in the law are affected because we're addressing just these two provisions, and those are the individual health insurance mandate and the impact on state budgets from the large increase in Medicaid spending that is mandated for the federal government and for the state governments. Let me address those each in turn. Florida has raised concerns about the Medicaid spending requirement because for them, the additional cost of their state budget will eventually top more than $1 billion per year. They're concerned that such a large amount effectively takes over a big part of their budget because, as they point out, they really can't opt out of Medicaid. So for them, they think there's a question of state independence, state sovereignty, if you will, or at least control over their state budget. And so they wanted very much to be able to raise that concern. For me, the number one concern, and the provision that concerns me the most, is the individual health insurance mandate, which is contained in the bill. This is the first time in our country's history that the federal government has attempted to order all Americans to go out into the private marketplace to buy a private product. And it isn't just any product. If you're not covered by health insurance from your family or from your employer and you have to go out and buy insurance in the private market, you have to buy an insurance policy approved of by the federal government. You have to buy one that the IRS says qualifies under this plan because you're reporting that you've made this purchase to the IRS each year when you file your tax returns. I think that this requirement of individual Americans is outside the power of the federal government. The 10th Amendment to the U.S. Constitution says that powers not expressly delegated to the federal government are reserved to the states or to the people. This isn't a states' rights case. This is an individual rights case. It's about whether individuals can be ordered by the federal government to go out and spend their own money in the private marketplace. The other concern I have is that this mandate is outside of the Commerce Clause power of the Congress. Some are saying that Congress regulates commerce and that a decision not to buy health insurance is somehow implicated by the Commerce Clause. To the contrary, I think that people who are refraining from commerce, who don't want to enter the stream of commerce, cannot be ordered to do so by Congress under the Commerce Clause power. Others say that this provision is within the power of Congress because they make the fine that you have to pay if you don't buy a qualifying health insurance plan a so-called tax penalty. In other words, they try to turn the fine into a quote-unquote tax penalty in order to make it look like some sort of tax and bring it within the scope of the tax and spending clause of Article 1 of the United States Constitution. I disagree with that. I think we all know what taxes are. That they're money that we pay to the government, and we receive benefits from the government because we pay our taxes. It doesn't make a fine into a tax just by calling it a tax penalty. So this concern, along with the Medicaid concern raised in Florida suit, will be brought before the federal courts, and first of all in district court, then probably in the Court of Appeals. Who knows, maybe up to the U.S. Supreme Court, depending on who prevails and who appeals. But in the meantime, I feel very strongly that it is incumbent upon me as the Attorney General for Washington State, who took an oath to uphold and defend the constitutions of our state and of the United States, to step up and defend the individual rights of Washington residents. That's exactly what we're doing in this lawsuit. The judiciary will ultimately have the final say. Meanwhile, all the other provisions that are in the bill, the provisions governing children's health insurance coverage, pre-existing conditions, you name it, they all will take effect as scheduled in the legislation, because we're not challenging those provisions. We're not saying that any other part of the bills is unconstitutional at this point. We're just addressing these very specific provisions which we think have a big impact on individual rights, and in the case of Florida's concern about Medicaid, on their state's sovereignty as a state. If you have any other questions, please come to our website and visit other parts of the website where we've posted frequently asked questions. There's a copy of the filed complaint in the Federal District Court, which you can read for yourself. And if you have questions beyond that, you can always send us an email. We'll do our best to answer. Thank you very much for your time today.